How to get a petty theft misdemeanor expungement. Petty theft, which refers to the theft of property worth less than $100, is a Class C misdemeanor in Texas. In some situations, you may be able to have petty theft arrests and charges expunged from your record. Here's a quick guide. What qualifies as a petty theft? The term petty theft can be used to describe any low-value theft of property. The most common type of theft is taking property without the owner's permission and not intending to give it back. However, Texas's theft statute also covers receiving stolen property. The lowest theft charge in Texas, sometimes called petty theft, is a Class C misdemeanor. If you don't have any prior convictions and the stolen property's value is under $100, you can only be charged with a Class C misdemeanor. A Class C misdemeanor conviction for petty theft won't land you in jail. The maximum penalty is a $500 fine. Can petty theft be dismissed? Some petty theft charges can be dismissed through the court's pretrial diversion or deferred adjudication programs. What is pretrial diversion? To participate in a pretrial diversion, the district attorney's office has to give you permission to be admitted into the program. If the DA allows you to participate in the program, you'll be required to sign a contract. This will include a zero-tolerance policy for crime. You'll also need to meet specific requirements for the time period you're in the program. Usually you'll have to take an anti-theft class. Sometimes the program will require you to pay restitution or do community service. If you stick to the contract and successfully complete the pretrial program, the charges will be dismissed. Once the charges are dismissed, you can immediately file a petition for expunction. What is deferred adjudication? With deferred adjudication, you will have to plead guilty to the theft charge against you, but a conviction will not be entered. Instead, the judge will defer a finding of guilt and place you on probation. During this probationary period, you'll have to complete an anti-theft class, and you may have to complete community service or drug and alcohol testing and evaluation. If you successfully finish your probation, no conviction will be entered on your record. You'll then be able to submit a petition for non-disclosure, which will prevent anyone but the police and a government entity from seeing a record of the charge. It's important for you to know that a non-disclosure is not an expunction. A non-disclosure essentially seals the record. An expunction erases the record as if the arrest never occurred. You're not eligible for an expunction after taking a deferred adjudication plea. Can I get a petty theft misdemeanor expungement? Under Texas law, you cannot expunge convictions from your record. However, you may be able to receive an expungement of petty theft charges and arrests in the following situations. If you were charged and acquitted, or if you were convicted but later determined to be actually innocent, or if you were convicted but later pardoned. You may have been formally charged, but the case against you was dismissed and the statute of limitations has expired. Or if you were arrested but not formally charged, you satisfy the 180-day waiting period for the expungement of Class C misdemeanor arrests. If you successfully complete pretrial diversion and get your charges dismissed, you can then file an expungement to remove the petty theft charge from your record altogether. What is the statute of limitations on petty theft? In Texas, the statute of limitations on all simple theft offenses, including petty theft, is 5 years. However, for thefts committed by fiduciaries or public servants, the statute of limitations is 10 years. The statute of limitations is an established time limit for the government to file charges against you. If charges are not brought against you before the statute of limitation expires, the government forfeits its right to prosecute you. The statute of limitations period starts when the crime is committed and runs continuously with a few exceptions. The statute of limitations deadline can be extended only under the following circumstances: during the time you're out of the state, or during the pendency of an indictment. Do I need a petty theft lawyer near me? If you've been charged with petty theft, you should contact a petty theft lawyer as soon as possible. Even though a petty theft conviction cannot land you in jail, a criminal record can seriously limit your employment opportunities. An experienced petty theft lawyer can help you fight the charges against you or enter the deferred adjudication or pretrial diversion programs in your county. It's typically wise to retain an attorney who regularly defends clients in the same court you've been charged in, even if you're charged outside of the county where you live. While choosing a petty theft lawyer near you may seem more convenient, it's crucial to have legal representation who understands the practices of the court you're charged in. This is particularly essential with theft charges, as pretrial diversion and deferred adjudication programs are generally run on the county level. If you have any questions, call or email us anytime. At Attorney911, we defend people like you every day and sincerely want to hear your story. Thank you for watching.